Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, in civil cases, many time it happens that court imposes cost on the other party. What is cost? What is the legal provisions of cost? What is section 35B of the Code of Civil Procedure? In this video, we would like to discuss. Before I proceed further with my video, I would like to request that if you have not yet subscribed my channel, kindly subscribe my channel, and if you like my videos, kindly like and share my videos. Friends, section 35B of the Code of Civil Procedure says about the cost. In the proceedings of suit, friends, many times court imposes cost for non-compliance of order. Court used to give certain time frame to for compliance of that order, but many time it happens that party does not comply the orders of the court. So in order to get the order execute the court used to impose the cost on the party who does not comply the order of the court. So section 35B of the Code of Civil Procedure I would like to read. Cost for causing delay. If on any day fixed for the hearing of a suit or for taking any step therein a party to the suit fails to take the step which he was required by or under this court to take on that date, or obtains an adjournment for taking such step or for producing evidence or on any other ground, the court may, for reasons to be recorded, make an order requiring such party to pay to other party such cost as would, in the opinion of the court, be reasonably sufficient to reimburse the other party in respect of the expenses incurred by him in attending the court on that date, and payment of such cost on the day next following the date of such order shall be a condition precedent to further prosecution. What does it mean? Supposingly, one party is coming to the court for producing his evidence, and the other party is unnecessarily, just for the purpose of delaying the proceedings, is not doing the cross examination, and a huge expenditure incurred of the witnesses of that party, then he may request the court, his pleader may request the court that, sir, such and such expenses has been incurred and he is causing delay and he is not doing that proceeding for which the suit has been fixed, kindly impose the cost. Or the court suo motu without any request can impose the cost. To whom it is payable? It is payable to the other party so that the other party can meet the expenditure whatever incurred to attend that date. Now the question is that we would like to discuss that what happens if the party upon whom the court has imposed the cost does not make the payment. We would like to discuss with a Supreme Court citation. First, I would like to further read section 35B subclause 2. The cost ordered to be paid under subsection 1 shall not, if paid, be included in the cost awarded in the degree passed in the suit, but if such costs are not paid, a separate order shall be drawn up including the amount of such cost and name and address of the person by whom such costs are payable, and the order so drawn up shall be executable against such persons. What does it mean, friends? It means that if a party fails to comply with the order of the cost and does not make the amount of the cost paid to other, then the court make a separate order and name and address of that person who has not paid the cost and to whom it is payable shall also be mentioned in the order, and that order is executable like a decree. As you know that in civil case decree is executable, so that order, that separate order, is also executable just like a decree. Now the question arises, when court used to impose the cost. So generally when a party taking unnecessary adjournment, number one, not doing compliance of the order. Supposingly the court has given the order that kindly produce affidavit, kindly produce certain documents on the next date of hearing, and the party is seeking unnecessary adjournment and not making compliance of that order, in that condition, court used to impose the cost. Not producing evidence is other condition. Not filing the reply to the application is other condition. Not doing arguments, supposingly the case is fixed for arguments, and one party is not willing to do arguments and deliberately delaying the proceedings of the suit, then in that circumstances also court used to impose the cost in order to bound that party, so that on the next date of hearing he will make and advance the arguments. And the other condition is not producing the document as per the orders of the court. We have discussed this earlier. Now what happens and what trend is, now generally what happens that the cost is being to be paid to the opposite party, but nowadays the court used to order that certain amount of cost should be deposited in the legal aid and certain amount of cost should be paid to the opposite party. How can we save ourselves so that the court may not impose the cost? First, it is advisable that you should not take unnecessary adjournment. Please make the compliance of the order within a time framework. Whenever court grants adjournment for making compliance of any order, like producing evidence, producing documents, filing an affidavit, so on the next date of hearing, make sure for the compliance of order, so that if you make compliance of order, the court will not or may not impose the cost. Now the very important question arises: can a suit dismissed for non-compliance of order of cost? The Supreme Court has answered that the suit cannot be dismissed. Then what can be happened? The person upon whom the cost has been imposed will not be allowed to proceed further or take part further in the further proceedings. Supposingly, a condition precedent that you have to cross-examine on the next date, and in case you will not cross-examine the witness of the opposite party, 1000 rupees cost will be imposed, or 1000 rupees cost imposed on the condition that you have to cross-examine the witnesses of the opposite party. But even on the next date of hearing, you does not pay the cost, so the court will not permit you to cross-examine the witnesses of the opposite party, because it was the condition precedent in the previous order. So you have to make compliance of that order. You have to pay the cost, otherwise court will not permit you to take part in the further proceeding, but court will not dismiss the suit as per the verdicts of the Honorable Supreme Court. The Honorable Supreme Court, very important case, SLP number 2203-2204/2008, Manohar Singh versus D.S. Sharma and another, what has been held by the Honorable Supreme Court. I would like to read. The Honorable Supreme Court in Manohar Singh versus D.S. Sharma has examined the scope and ambit of Section 35B of the Code of Civil Procedure. While examining the nature of the provision, the court has considered whether non-payment of costs by a defaulting party could lead to dismissal of a suit. While negating the aforesaid question, the Supreme Court has held as under. What the Supreme Court has held? That a suit cannot be dismissed for non-payment of cost. Non-payment of cost result in forfeiture of the right to further prosecute the suit. So it has been categorically held by the Honorable Supreme Court that non-compliance or non-payment of cost would not result in the dismissal of the suit. So friends, in this video we have learned what is cost, when court used to impose the cost, and the suit cannot be dismissed, but the person will not be allowed to take further part in the proceedings. Thank you so much, friends.